It looks like royalty has been rejected at the USPTO, United States Patent and Trademark Office. We're going to get off all into it today. I am Dave, a 10-year intellectual property attorney dealing with everything from copyrights to patents to trade secrets. And today we are talking about trademarks. Now, Meghan Markle, I think is her name. Yeah, Markle, who's married to Prince Harry. Apparently they stay out in California, which we'll get off until later because that's a reason for this trademark. And seems like she's forming a business selling jams and like a lifestyle brand. So she filed a trademark to try to protect her name of her brand, American Rivera Orchard. Now, this is interesting because on the one end, she's actually doing the thing that I will employ all of you guys to do as far as file for protection on your intellectual property, whether it's a copyright, whether it's a patent. In this case, it's a trademark. So she's taking the first step in terms of protecting her intellectual property by way, in this case, a trademark. Another interesting thing about all this is, man, you have these entertainers, these celebrities, they are maybe making money in whatever it is that they're doing, but at the end of the day, they know where the bread is butter, and that is intellectual property stuff. Whether you're, trying to form and grow a brand, that's trademark. They're going to protect their trademark. You hear about all these rappers who are crying about the masters and such. What they're essentially saying is they're crying about, hey, somebody owns the copyright to my work. Again, or a different form of intellectual property. Whether you're starting a business, you have all these technologies. Those are patents that you can get. So it's interesting to me that even though, especially the celebrities as well as the entertainers, they're making money just, I guess, being a celebrity and entertainer. But as they grow their brand, they're still looking to protect their intellectual property. I think one of the Paul brothers who has Prime, I think I did a video on him a month or so ago, but he has the whole Prime, the sports hydration drink that he's kind of using this celebrity to try to grow this brand. And again, they have a number of trademarks on the brand, Prime Hydration. And again, this stuff becomes important because now when you go to exit a deal, then part of that exit and part of what people are paying for is the intellectual property. So it's good that the celebrities is good, but I think it's interesting that all these celebrities, entertainers are indeed protecting their intellectual property, whatever that may be. Again, in this case, which we'll take a look at this article from New York Post, the trademark office unfortunately rejected her trademark. Now, what does this mean? This means a couple of things. This means that she is probably going to, do a name change and kind of have to rebrand altogether, or she can actually argue against the rejection that was handed down by the United States Patent and Trademark Office. But for me, again, when I'm doing this stuff, I want to not only kind of bring you guys the news, bring you guys what's going on, the current event, but also want to bring you guys the information. And I think this is a good teaching moment as you yourself, hopefully one day, you get off into this intellectual property ownership game. I'm going to let you know what you could have done to avoid being in this in this situation. And I'm also going to let you know how Meghan Markle, the wife of Prince Harry, how she can actually maybe still get her trademark on American Rivera Orchard. So we're going to talk about it all today. Now, before we do this, I have to first kind of break down a little bit of a trademark. Now, a trademark, we all know it identifies the source of the goods or services. So in this case, again, it seems like Meghan, she's creating this lifestyle brand that she's, amongst other things, is selling, say, jam, for example. And as a result of that, the American Rivera Orchard, she's looking to protect her trademark, to protect the what we call a word mark in this case, which is American Rivera Orchard. Now, when you go to protect your trademark, the trademark falls into a number of different classes, and I'm gonna go through them really quickly here. We have a generic mark, which is not, you would never be able to get a trademark on a generic mark. Think of aspirin. It's so generic that people can be talking about Tylenol, people can be talking about Aleve, but they generically say, hey, can I get an aspirin? They're dealing with pain and headaches and things like that. Those generic marks would never be able to get trademarked. The next one is descriptive. It describes the nature of the goods and services. And those marks are not, you can't protect them and get a trademark on them at the beginning, but later on through what is called acquired distinctiveness, or what we call secondary meaning, you can get a trademark on those descriptive marks. Think of U.S. news report. It's talking about news in the U.S. Think about the Weather Channel. It's a channel that's discussing the weather. Those are not at the beginning protectable, but because they're descriptive of the nature and services, again, the Weather Channel describes what it is that they're talking about, which in this case is the weather. Those are not protectable at the beginning, but you can actually get a trademark or protect those things later down the line. And that's going to, just put that in your back pocket, because that's going to become important as we get off into this video. So then the next mark is suggestive. Now you can protect, when you start at the suggestive mark, now you can start to protect those terms, which is suggestive. And it kind of, it requires imagination from the consumer. So think of Netflix. You have, internet, you have pictures. It's a streaming service. So you have to conjure up as the consumer some type of imagination. The word kind of suggests the services, but it's not descriptive of the services. It kind of suggests what's going on, but you still, as a consumer, need some, need some type of imagination. Think of Facebook. Okay, faces, a book. Okay, it's a social media platform, but it suggests what's going on, but you still, as a consumer, you have to kind of use your imaginations to kind of figure out what's going on based on the name. So those are suggestive marks. Netflix, Facebook are two examples, and those are they are strong enough to get such that you can get protection. And then you have what we call is an arbitrary mark, which it exists, but you're using it in a different way that people typically know it. The most famous one, at least in my opinion, is Apple. We know Apple as being a fruit, and now you had the technology company Apple used it to describe their technology products and services. So that's an example of an arbitrary mark. You're using an already known word in an arbitrary sense, and those are very strong. You get a very strong protection on those. Then the last form of a mark is a fanciful mark, and that's essentially a made-up word. Just think of a lot of those drug names. Those are made up words. And then also think of, I think Twitter, somebody was saying the other day, you guys have to let me know in the comments if this is true. They said Twitter is a made up word. So to the extent that you have a made up word that you're going to trademark, that's also going to get the strongest form of protection right along the lines or right along with an arbitrary mark. So you have a generic, descriptive, suggestive, arbitrary, and fanciful. Now, in this case, with Megan's mark, which again is more of a phrase, American Rivera Orchard, you have a rule in trademark law that states that if you have your mark is kind of more of a geographical mark, then you have to kind of go through these three prongs or questions you have to ask yourself. And if these three questions are true, then you cannot register that mark, at least at the beginning. So what's the first prong? The primary significance of the trademark is generally known geographical place. So again, I'm here in the Midwest, and I'm not, I guess, big out on California, but essentially, or apparently, American Rivera is, another name for Santa Barbara, California. So again, we're talking about this geographical limitation, if you will, that the United States Patent and Trademark Office gives. Again, the first prong, the primary significance of the trademark is a generally known geographical place. You can check that mark because American Rivera, hers is American Rivera Orchard. But again, the name American Rivera is a known geographical place. What's the second prong? The goods and services originate in the location identified by the trademark. So it seems like the jam and all the other stuff that she's selling is originating in the American Rivera or in Santa Barbara, California. So check to that second prong. Then the third prong is the purchasers are likely to believe that the goods and services originate in the geographical place identified in the mark. So again, trademark law is really to protect you and I as consumers. So again, in this case, if you're purchasing a jam, are you thinking, if again, when a examiner at the USPTO does his analysis or her analysis, if that third prong, if he or she is saying, okay, people, when they purchase these products or purchase these services, they're going to think that they are originating in that geographical location, in this case, the American Rivera. So if these three prongs are met, you cannot get that trademark at the beginning. And again, going back to what I was saying at the beginning, and how could she avoided this situation at the beginning? And I'm assuming that she got some smart attorneys, and her attorneys told her, like, the chances of you getting this mark is pretty low because of this geographical limitation that you're going to go up against. Where again, if you answer 3 to all these questions, the trademark is a generally known geographical location. Yes, that's true. The goods and services originate in that geographical location. Yep, it's true. Those goods originated in California. Then number three, if the public, the consumers that's purchasing the goods are thinking that they came from that geographical location, if all those three questions are marked in an affirmative, yes, 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 then you're not going to be able to get a trademark. So I'm assuming that Meghan Markle, her attorney told her this, that, hey, we're probably not going to be able to get a trademark again. I know sometimes you as clients, y'all want to push forward anyway. Hey, I have a trademark that I'm in the process of filing, and I told the client, like, man, it's going to be tough to get this one just in light of a lot of stuff that was out there, but and they still want to go ahead. So ultimately, you're the client, and you're going to make the decision, and obviously, you're paying the money. But I would imagine that Meghan Markle's her attorney told her this, and she said, "Let's try it anyway." And this again, to her credit, there's no harm in trying. You spend $1,000 or whatever the case may be, and if it doesn't work, then no harm, no foul. However, this is the interesting thing. So I guess when you're looking to think of a trademark to get protected, or think of a mark to try to get trademark or protected, and it's based on a geographical location, then you probably want to go through this analysis in terms of, again, I'm gonna do it one more time. Is the primary significance of the mark generally a geographical, a known geographical location? Again, if it's not a generally known, you may be in a better spot. But if people know the name of it, the geographical location, then it's probably not going to look good for you. So that's step one. Again, step two is the goods or services originate in that location. So if you're making pizza in California, you try to trademark California pizza, it's probably going to fall within that second prong, and that's going to be a yes, which is not to your benefit. Then the third one, if the purchasers are likely to believe that those goods and services originate in that geographical place that's listed in a trademark. If all those three are yes, 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 then you're not probably going to be able to get that trademark initially. So again, we talked earlier about generic, descriptive, suggestive, fanciful, and arbitrary marks. And these type marks is geographically descriptive. So it falls within that descriptive category, which, if you were paying attention early on, I said you cannot get those trademarked initially. However, through acquired distinctiveness or secondary meaning, they can become a trademark later on. What does this mean, David? This means that if you can show the United States Patent and Trademark Office, like, look, man, we got $100 million in revenue, or we have 50 million, or some large amount of revenue, to the point that you can kind of essentially give evidence and convey to them that a lot of people know this because of us, not because of the geographical location. That's, again, if you can provide a lot of sales, and again, this is not a hard rule. Like if you say it's 5 million or 10, again, it's kind of in totality of things. But if you can show that, and the higher, the more sales, the better. But if you can show the USPTO that, and we did 50 million in sales last year under this name, then that's going to start to kind of give you that distinctiveness, that secondary meaning that it has acquired. Another form is consumer reports or consumer surveys. So if you going out doing surveys, and the consumers out in public on the street, if they're saying, hey, we know this mark because of, not because of the geographical location, we know it because of his or her actual business, or the sort, they're identifying your company as a source of the goods, as opposed to identifying the geographical location. So you're saying, okay, American Rivera, they're like, man, a Megan's company, American Rivera, they have some good jam, as opposed to, oh yeah, I know the American Rivera stuff, Santa Barbara, California. You don't want them to identify the name with the actual location. You want them to identify the name with your company. So that's, again, another way. Again, that's part of consumer reports. Then the last thing I would probably say is a big one is advertisement. There's some others, but these three, at least in my opinion, are generally the big ones. Sales, consumer reports, and advertisement. If you can, show the USPTO that you're spending 50 million or 10 million in advertising to try to get the word out there that, hey, this is not a geographical location, or this is not the mark is not because of a geographical location, but it's more so it's because it's coming from our company, as opposed to it coming from a geographical location. All those things are going to help you out. So although, and people are not talking about this, although she was rejected, she can, if she doesn't want to, for whatever reason, she doesn't want to change the name, and she wants to actually fight it, she probably doesn't probably don't win right away, but she can still actually, hey, just come out with it, put the TM on it. Again, a R in the circle means it's a registered mark, but a TM just means that you're using it as a trademark term, but it's not registered. So she can do that. And then just over time, maybe it takes a number of years, but she can come back to the USPTO or go to the courts and say, hey, this should be a registered trademark because it has acquired distinctiveness. Therefore, it's no longer just a descriptive mark, but it has kind of bumped up. It has acquired distinctiveness. So hopefully you guys got something out of that. Again, I'm trying to provide you guys value. Let me know in the comment section if you are picking up what I'm putting down. Essentially, the takeaways from this is Meghan Markle, the American Riviera Orchard, the trademark that she was just rejected. You probably should think twice if you were trying to have a trademark on that's based on a geographical location. Again, go through those three-prong analysis that I gave. Is the primary significance of the trademark a generally known location? The goods and services originate in that location, and then do the consumers believe that by getting those goods or getting that service that they're coming from the actual geographical location? If those three are affirmative, then you're probably not going to be able to get a mark. So you probably want to maybe rethink filing that trademark application and spending that money. But to the extent that you want to still file it, and you're probably not going to get a trademark anyway, but if you still want to kind of get a trademark at the beginning anyway, but you still want to get a trademark ultimately on that name, then you just have to, over time, you can acquire this, the mark can acquire distinctiveness based on your sales, based on your advertising, and based on consumer reports. So that's, again, hopefully you guys are picking up what I'm putting down. Let me know in the comments. Please hit a like if you like this video, and also hit the subscribe button if you haven't. Hit the subscribe button if you haven't already subscribed. Again, I'm trying to give you guys, as a 10-year intellectual property attorney dealing with everything from trademarks, copyrights, patents, trying to give you guys not only the current events, but some information as well, so that you are better equipped to go out, be able to protect your mark at the beginning, and then not only that, make a lot of money. Because hey, what's with all this IP if you're not making money off of it? So until next time, you guys take care. Peace.